Hello everyone. We will be starting the webinar sharp at 12 p.m. Eastern Time. That is in about 4 minutes from now. Thank you. It is 11:59. We will be starting the webinar in under a minute. All right. We will start today's session. Today I'm joined alongside Prashanthi Reddy. Prashanthi is an award-winning immigration attorney specializing in immigration law. With over 25 years of experience, she is an esteemed member of the American Immigration Lawyers Association and the New York Bar Association. She's also currently admitted to the Bar Association in New York. Prashanthi is also currently serving as an advisor slash immigration counsel for Indian Consulate in New York and is actively involved in pro bono legal work. Being in the industry for such long and for her commitment towards her work and clients. She has achieved many rewards and recognitions. Some of them includes Forbes listing her as one of New York City's best immigration lawyers in 2024, amongst other accolades. I'd like to welcome Prashanthi now. Prashanthi, you can take over from here. Thank you. And before we jump into Prashanthi, I just want to remind everyone that today's session is a Q&A session as well by the end of the presentation. So you will have opportunity to ask any questions to Prashanthi. Throughout the presentation, you can type in your question in the chat window if you are joining the stream directly, or from any of the socials that you're joining us through. We will be happy to take your questions by the end of the presentation. Prashanthi?
Yes, thank you, Vishal, for that introduction. And let's go straight to the topic. We're starting off with some immigration updates, and then we'll go to the actual topic. We have two topics. I hear someone is not able to hear my voice. Can you hear, Vishal? I see a text. Divya is not able to hear my voice.
Yeah, I think we are fine. Maybe Divya is having some issues.
Divya,
if anyone else is having issues, please let us know on the chat box.
Oh, okay. Now Divya can hear. Okay,
All
good.
right, thank you.
Thank you. Thank you for confirming. So we will start, as I said, with some updates, immigration updates, and then we'll go to the topics. We have two topics for today. One is family-based immigration, and the other one is employment-based, EB2 versus EB3. So starting with our immigration updates, we're going to talk about first what everybody is looking at, a hot topic, the H-1B proclamation, the President's proclamation. The reason we're talking about it today is because last week there was an update from USCIS, further informing us who falls under the proclamation and who doesn't. So that's important. That's why it's important to look into this again. Updates on this as we go by, and as it comes to next cap season, we will hear more, I'm sure, because there have been lawsuits filed. I think two lawsuits filed so far with reference to this. So we'll hear more, and I will let you know as soon as I get more information. I will give you that information as well. So just to give you a recap, the proclamation was announced on September 19, 2025, and this is based on two sections of the law, 212F, which is a travel ban, and 215A of the Immigration and Nationality Act. And the reason to do this, as per the administration, is so that they can stop the influx of low-wage foreign workers who threaten American jobs, is the reasoning that they've given. Under certain circumstances, if you are on a H-1, you have to pay a $100,000 fee. And of course, there are exceptions to this. There's some national interest exceptions. So if you're within the, if you can show that it's within the national interest of the United States to waive the $100,000 fee, that can be waived. It's kind of like a national interest waiver petition. And the proclamation also says that they're going to increase the wages for H-1Bs. So there are two points in this proclamation. Next slide. So who qualifies and who doesn't? So if you look at this table, it'll give you an understanding of who qualifies. A new H-1B filed on or after September 21, 2025, who is outside the US and who does not have a valid H-1B visa. So anyone who's outside the country and does not have presently a valid H-1B visa is subject to the $100,000 penalty. And this is the intended people that, we always knew it was intended for. But of course, now we don't know whether cap exempt people it's applicable to cap exempt people. So if you were on a H1 5 years ago and you left and now you're coming back, but you were counted towards the cap, does it apply to you or not? That question is still not answered. But with reference to new H1s, people who have never been on a H1, we know clearly that they are subject to the cap. That's never been a point of contention. So if the petition was filed on or after September 21, and you're requesting consular processing, meaning you may be in the H1, if you may be in the US on a H1, but because you're not able to file a change of status, or maybe because you don't want to file a change of status, or an extension or an amendment, you're actually filing consular processing, you're asking for consular processing. An example of this would be if you're out of status and you're unable to ask for a H1 extension, you might go for consular processing. If it's a F1 to H1 change of status, maybe you don't want to change to a H1 immediately. You want to go through your STEM OPT and use those years and then, move to a H1 later on when you're ready to. Then such people usually file for consular processing. But if you do now, you be careful about doing that. I would suggest to file a change of status instead and not file consular processing. Of course, there are circumstances where you cannot avoid it if you're out of status, and so in those situations, you'll have to pay the 100,000 proclamation. Petitions filed after September 21, which were filed for an amendment or an extension or a transfer, but USCIS denied that request for amendment, extension, or transfer and only approved it for consular processing. So this is, you're asking for an extension, but USCIS deemed that you're out of status, and therefore they did not approve the extension or the change of status portion of it, but approved the H1 only for consular processing without giving you an I-94. In these circumstances, then you will be the proclamation will apply to you. September 21, 2025, the proclamation doesn't apply to you no matter what your situation is. So even if you were a cap case from last year, if you're going for a visa, it doesn't apply. Beneficiary has a valid previously issued H1 visa. So we're presuming that you already have a visa, you're just traveling in and out of the country using that visa, then the 100,000 doesn't apply to you. Petition filed after September 21 for amendment, extension, transfer, proclamation doesn't apply to any extensions, transfers, amendments, any of those cases where you're inside the country. If you are on a H1 and then you depart and apply for a new visa on that petition, and you want to, then you re-enter, does the proclamation apply? No, it doesn't, even in this page. So I hope that kind of gives you a bird's eye view of who the proclamation applies to and who it doesn't. Can we go to the next page? Yeah, thank you. Let's now talk about the November Visa Bulletin. This is also of immense importance. So as per the November Visa Bulletin, for all family-sponsored preference categories, you must use the dates for filing chart. So that's a good thing because the dates for filing chart are usually ahead of the final action date chart. So that's the first thing. Next, and we've also seen that, next slide, we've seen that there's not much forward movement, but the good news is there's no backward movement either. So if you look at the dates, starting with final action dates, for most categories, there's no change except for Mexico and Philippines. For F2B, there's advancement of 9 days, sorry. For F3 category, Mexico advances by 16 days. Otherwise, there's no other change in the final action date table for family-based cases. Next slide. For employment-based preferences, we see no change across the board. This is good news because we know that there was dramatic forward movement for EB2, EB3, EB1, especially for the backlogged countries for India. So the good thing, because now people can continue to make use of those dates that have moved forward, and they don't have to file in October. They can file it in the month of November as well. So this is good news, and hopefully we will see some forward movement as we go into next year for EB3 and EB1. Next slide.
Prashanthi, the slide is changed, and also want to let you know that I think because of your internet connection today, every now and then we are experiencing some freeze. Your video and audio both are freezing momentarily.
And the slide, for example, okay, now I see it. Maybe there's a delay in seeing it.
Yes, there is a bit of a delay today. Yes. So apologies to everyone if you're experiencing some lag. There are some technical challenges with today's stream so far.
It's the internet, and there's not much we can do. I do have great internet service, so but it sometimes happens.
Yes.
Let's hope it corrects itself. But yeah, so moving forward, looking at the dates for filing chart for employment based, again, no change. So we'll go to the next slide. And that's good news that there's no change. So let's look at a recap of what happened. Basically, there's some small advancements in the family-based category, as we saw. For all employment-based categories, we haven't seen any. And there is a retrogression. There's no retrogression, which is good for the month of November. Next slide. What predictions do we have for the moving forward? We will see some continued forward movement, I think, in the family-based category, especially in F2A, that is spouses and children of green card holders, and F2B as well. Especially for Mexico and Philippines, we might see some progression every month in early 2026. F1 and F4 are expected to hold steady. At least there's no retrogression unless we see some unexpected surges. F4 is brothers and sisters of US citizens. For employment-based, we expect this year to remain flat. However, EB2 and EB3 India are projected to move forward slightly, possibly in early 2026 or early summer of next year, depending on, again, visa number availability and the demand. We don't expect any new retrogression, at least throughout this year, which is a good thing. So we expect that the dates to remain current and remain in the same situation for November, we already know, and for December as well. So that'll give you more opportunity to file your case, but I wouldn't take any chances. If you are current for the month of November, as you have been in October, I would file in November and not wait until December, until we know more. Next slide. Now let's talk about EB2 versus EB3. This is a good segue into this next topic because we've looked at the Visa Bulletin. Now we need to look at, we've seen that EB2 sometimes moves forward, EB3 moves forward. So which one is a better category to be in? So let me start by saying that right now EB3 is moving much faster than EB2. So, and the other good news is if you qualify for EB2, you also qualify for EB3, but it's not the other way around. So if you're filing a perm, I would not file in EB3 if I qualify for EB2. I would do EB2 and then file another I-140 in EB3 as well. So what I would do is have, if I qualify for EB2, then I would also file an I-140 in EB3. So I would have two but I would file a fresh I-140. So I would have two I-140s, one for EB2 and one for EB3, especially if I have a master's or if I have a bachelor's plus 5 years of experience, in which case I would qualify for both. So I would, as I said, the perm will be filed in EB2, and the I-140, I will have two I-140s, one filed in EB2, because that's what I qualify as, but I could also downgrade to EB3 because I qualify for that as well. And I would file that in EB3. So again, perm is in EB2, but the I-140s, I would file both of them, one in EB2 and one in EB3. I am just repeating this because it can be a little confusing. Next slide. So looking at EB2, you do need, let's look at the differences between EB2 and EB3 and what the requirements are. For an EB2, you require a master's degree or higher, bachelor's plus 5 years of experience. You require labor certification, but it's possible that you can file a national interest waiver as well under EB2, and in that case, then you will not require a labor certification. Then you have to show that it is within the interest of the United States to give you a green card and to not require perm certification. For example, if you are working in research, if you have some kind of a public interest work that you can show that it's in the interest of the public, your work is useful to the public in some way. If you are an innovator, then it's possible to file a NIW. Next slide. For EB3, the person should have at least a bachelor's degree, provided, of course, we're skilled worker, EB3 professional, sorry. There's also EB3 skilled worker where you do not require a bachelor's degree. But talking about EB3 professional, you require a bachelor's degree. And for a skilled worker, you need at least 2 years of experience in the field. There's also other workers which fall under the EB3 category, that is unskilled workers where less than 2 years of experience is required. In all these categories, an approved perm labor certification is required. Self-petitioning is not allowed. There's no NIW category under EB3. EB3 usually has a long wait time because so many people qualify, but there's an anomaly when it comes to now, because right now we're saying that EB3 is doing better than EB2, and that's because there's more demand for EB2 because a lot of Indian or have bachelors and many years of experience, so they qualify for EB2, and therefore there's a more demand for EB2 than there is for unskilled workers or skilled workers or professionals, and that's unusual, but that's what's happening right now. Next slide. So the differences, you can look at this table and see what the differences are. EB2 requires a master's, EB3 requires bachelor's plus 2 years of experience. Skill level for EB2 is advanced. In EB3, it's professional, skilled or unskilled. Self-petitioning is possible in EB2, not allowed in EB3. Perm is usually required in EB2, except for NIW. EB3, it's always required. Processing time generally is faster for EB2, but EB3 there's a backlog. But as I told you now, the reverse is true. And is usually lower for EB2 versus EB3, but we've seen that that's not the case with the influx of all the Indian workers and all the IT workers. So choosing between EB2 and EB3 really depends on what your education and experience level is. But I would definitely file for EB2 if you qualify. File the, as I said, perm for EB2, and then file an I-140 under both EB2 and EB3. Next slide. So a major advantage of both EB2 and EB3 is that your family members can accompany to join you, can accompany you, can file with you. Spouse will file E21 or E31 visa category. Unmarried children can file. So dependents, immediate relatives can file with. Is a huge advantage, and they will also get EAD and advance parole along with you. So the family can migrate together or can remain in the country and work and live together. So that's a big advantage of both EB2 and EB3. Next slide. Now let's talk about the family immigration. This is our the second topic for the day, equally important. Let's first talk about, we're not just going to talk about the processes or what how to file. We're going to talk about some issues that you can face if you're filing for a family petition. A family petition is available for immediate relatives, and it is also available for, so generally US citizen, spouses, children under 21 unmarried, and parents come under immediate relatives. You can file an I-130 and 485 together for these people, as long as they're in the US. If they're outside the US, then you have to file an I-130 first, and then go through consular processing, NBC, and interview at the consulate. The good thing about the immediate relative category is that there is no visa number requirement. So there are no backlogs with reference to visa numbers. The only backlogs are with reference to processing times. So currently, processing times for family-based cases are not very fast, not very good. It's about 12 to 18 months. For the I-130, depending on the type of I-130, if you're an immediate relative, I-130, it's faster. If you are one of the other categories where the visa number is not available, they don't give priority for processing the I-130. As I said, backlogs for family-based F2A, F3, F4. This is F2A is spouses and children of permanent residents. F3 and F4 are US citizen, married, children who are over 21 and married, etc. So the preference categories, these are the preference categories, F2, F3, and F4. These take a little longer because they don't give preference. They don't give preference in processing also, because the visa number is anyway not available. Many of the denials in this situation originate from eligibility or poorly prepared cases or mistakes in submitting evidence or in filling out the form. So be careful with reference to these things. So as I was saying, most of the denials in family-based cases originate from proof of relationship, inconsistent information in the I-130 and 485, and in prior filings. So example, you put your work site as something else in your 485, and on your H1 it's something else if you're on a H1, then that can lead to denial because the information is inconsistent. Not enough or not sufficient proof of bona fide relationship. You are able to submit affidavits, but if they're not notarized, then the case can get denied. If you don't have proper birth certificates, the case can get denied. Marriage certificates. If you don't prepare properly for the interviews, and we'll go into the interviews more in detail, but that could lead to denials as well. Next slide. So again, talking about processing times, that processing times is one of the issues with reference to family-based cases. So you have to anticipate longer processing times, and especially if you're going to the consulate, NVC, and then getting an appointment at the consulate for an immigrant visa appointment also takes time. So you have to factor in all those things when you're looking at processing times. You can, however, avoid delays at the NVC stage by uploading all the documentation at one time rather than waiting for them to ask you for it. Sometimes you don't submit documents. Sometimes documents are not labeled correctly, so they're not able to see what they are, and they might send you another email for the same document because they can't see it. Sometimes there are issues with the document itself. They may not be clear, and then NVC again sends you an email for that documentation to be sent again. Avoiding these issues, you can, avoid processing delays as well. Also, the other issue is the financial eligibility. Sometimes cases get denied or there's an RFE because because of the affidavit of support. The family member may not be able to qualify for the minimum requirement under the affidavit of support. They have to have 125%, 125%. Their wage level has to be above the poverty guideline. In these instances, the way to strengthen your application is to use joint sponsors, meaning another person who is a family member or a friend can submit an additional affidavit of support along with you and attach their tax returns. And that's a way of avoiding denials or RFEs. Look at the Visa Bulletin, that is, follow specific trends with reference to the visa categories to understand the USCIS processing times and to avoid delays. F2A, is subject to delays, but sometimes they become available. Right now it's available, so you should process your case as soon as possible. Immediate relative categories, it might be a good idea if the person is already in the US and then you file for them, because you can then file an I-130 and 485 together. For immediate relatives, if you file an I-130 here and then you wait for processing at the consulate, that can add 2 years to the processing time, just because the consulates are so backlogged. Next slide. So there's a lot of valuable information that I'm giving you here. Please pay attention to it if this applies to you. For green card interviews, I want to talk a little bit about the green card interviews, about what to say and what not to say, and this also becomes an issue and may lead to a denial of your family-based petition. And this also applies to interview-based as well, any interview. Avoid contradicting yourself. Cross-check your answers first. Look at what's in the form and then answer based on what's in the form. For example, they can ask you what your last date of entry was. Maybe your form says something and you answer something else. Also with reference to your address or your last 5 years of employment, make sure that you are credible, you know what your information is, and it matches with the forms that you've submitted. Don't answer to the point. Don't over-explain, don't argue, don't create confusion. Stay calm and only answer what is asked of you. Don't answer anything beyond that. The other thing that you have to do is be honest especially about relationship issues, and this happens in family-based cases, sometimes in marriage-based cases. If you're living separately or you recently reconciled and you were living separately earlier, acknowledge that and explain whatever issues there were with your relationship. Officers will appreciate that transparency, and if you try to hide it, your paperwork might show otherwise. They might show that you have 2 different addresses. And also, if you have a long distance relationship, it's possible that the spouses are living apart because they're working in different states. Don't try to hide that. Explain the situation as to why you're living apart, and then that's not an issue, because officers do understand that sometimes you might have jobs at different places. And of course, last but not the least, dress and behave professionally. Come prepared. Organize all your folders properly. Have your originals in one place, your photocopies in one place. Be respectful always. Don't hesitate to ask questions and don't hesitate to ask the officer to repeat the question if you don't understand the first time, rather than answering incorrectly. Next slide. Some other tips that I wanted to go through quickly to avoid family-based denials. Make sure your application is complete and accurate. Double check everything. Double check, triple check. That's what we do in our office. There's so many forms. The I-485 has 25 pages or, something like that. So every column counts. Even if there's a missing field, if there's a checkbox left empty, if something is unsigned, there's so many issues that can happen in a form. So please make sure you triple check every form. Make sure you've signed everything properly, and all the supporting documents are properly translated and they're clear copies. Small errors can cause RFEs and sometimes even denials if you don't respond to the RFE properly. Another thing you need to do is always provide genuine and strong evidence. USCIS always relies on evidence, not on an affidavit from you. So your evidence is what tells the story. Include all your joint tax returns if you can, get transcripts from the IRS. For joint documents, especially in a marriage-based case, this becomes very important to show genuine relationship. You submit your insurance policies together, your bills to show that you're living under one roof, your lease, copy of your lease, your bank statements, joint tax filings. All this will paint a picture to show that you're living together and it's a genuine bona fide marriage. Affidavits or letters from your friends and relatives showing that you live together also helps in marriage-based cases. And in all family-based cases, make sure that you label everything in a chronological order, submit everything properly, maybe put evidence tags, use different color paper, whatever you need to do to make sure that it's clear to the officer, because you might be submitting 500 pages of documents and they may not go through all 500 pages. And also it's important to have an index so that they at least know what documents they are and they'll look for those documents. Next slide. Stay consistent across all the filings. I think we discussed that already. Prepare properly for the interview. We discussed that. Look at your visa bulletin. Very important that you look at the visa bulletin every month to see whether your dates are current or not. Maybe if they're current, then you can follow up with USCIS by interacting with Emma on chat or sending them a letter or calling USCIS. Next. And as I was saying, respond promptly, communicate with USCIS, respond promptly to any RFEs or NOIDs. Don't wait for the last possible minute because there might be delays with your package being delivered. So don't wait for that. At least I would respond at least a month in advance to account for any delays. Sometimes if you send it to the wrong address, by the time you know that you sent it, by the time they send it back to you, the date may be over to respond, and then your case gets denied for the small reason. Always seek legal guidance. As I said, these forms are complex and it's easy to make mistakes. So review carefully, or I would suggest that you outsource this, use a legal professional to file your 485, because there's questions there in the 485 and they might seem like yes, no answers, and they might seem simple enough, but there is a lot of law behind that. And then you don't know what the reason for them asking that question is. And sometimes when you don't understand why they're asking the question, you may not know how to respond. But in any case, always be honest. No misrepresentation, even if it's unintentional, will lead to permanent ineligibility. With reference to relationships, especially marriage-based cases, always answer truthfully. Don't submit fake documentation. Next slide. And with that, we're at our Q&A.
Yes, we'll open the floor to take any questions. Um, so whichever platform you've joined us to, you will have option to drop in your questions. So feel free to, and we will start answering them. In the meantime, Prashanthi, while we wait for any questions to come in, I can take a few questions from offline sources. So this one is, I got laid off in the last week of April 25, and within a month, last week of May 25, my current employer, company A, filed for the H-1B visa transfer and got the receipt of it. The transfer petition was not filed in premium, hence the visa petition is still pending as of October 25. They say it is expected to be approved within a couple of weeks or maybe a month. I'm actively interviewing and I have a couple of final round interviews lined up. In the case I end up receiving an offer letter and want to join company B, can they go ahead and file a new H-1B transfer with premium processing for me? If the company B's petition gets approved before company A, would there be any issue? What is the best solution? Please advise.
So the USCIS follows the last action rule. So whatever petition you file last is the petition that they will consider to be your status. So there shouldn't be an issue with filing multiple petitions. You can, uh, go with company B if that's what you want to do. But of course, in order to go with company B, you will have to show that you're within the 60 days grace because you cannot file the transfer based on the pending petition with company A. So you'd have to do a 60 days grace from the previous petition, the employer that you were laid off with. So that's something to keep in mind. As long as you're within the 60 days grace period, then you can file for company B as well.
Noted. Thank you. I'll move on to the next one. So my husband and I got married 2 years ago, and he also got his green card not long after that. For K1 visa, I changed my last name to his last name then and have changed my name on all documents except my passport. Will I have problems from USCIS for not changing my name on my passport as proof that we are actually married for the last 10 years green card renewal? For his 10-year green card renewal.
Uh, no, because once you have a green card, uh, you pretty much have a green card as long as it's not the temporary green card. Doesn't look like that because it's been 10 years since he has a green card. So the only time that you have to worry about renewal of the green card is when you get the initial green card for a marriage based case for 3 years and then you file for an extension of the green card after that. From a temporary green card to a permanent green card. But if it's already a permanent green card and it looks like it is, then they don't look at what your on what basis you got the green card anymore. It's permanent. It's only the card that is being extended, but your status, even if the card is not extended, remains a green card status. So no one can take that away from you unless there's a felony or something happens and they take away your green card from you, which is very rare, and it has to be done by following proper procedure. So in your case, there should not be any issue at all. But in general, in family-based cases and in marriage-based cases, if the spouse doesn't change their last name, I mean, it could be one factor to show that maybe it's not a bona fide marriage, but it's not the only factor. As long as there are other things showing that the marriage is bona fide, just that one thing that the spouse decided not to change their last name should not be held against them.
Okay. We have a question from Divya Karunam. Can we do transfer without LCA certification?
Right, and I know why Divya is asking this question because of the lockdown right now. Uh, the Labor Department is not functioning, so the website is not working, so we cannot file an LCA. And there might be instances where you would need to file an extension or a transfer or whatever it might be, and such people are under, have issues, obviously. But to answer your question, no, you cannot file a transfer without an LCA certification. But what USCIS is saying that even if your status is expiring, say 60 days grace, or say you've lost your job, uh, or your extension is expiring, your I-94 is expiring, and you have to file an extension, USCIS is saying that they will accept such late filings because under the circumstances, because of the shutdown, you could not file an LC on time. So that comes under exceptional circumstances. So USCIS has recently said that they will accept those cases. But of course, we cannot, that's not a guarantee. So in this instance, if you are stuck in such a situation, I would just file a change of status to a B2 first, and then figure things out later. File the petition whenever the LCA portal opens up, the flag portal opens up.
Sorry, I was speaking on mute. I will go to the last offline question. And in the meantime, also encourage anyone streaming today's session. If you have a question, feel free to drop in your question. We still have a few minutes. Prashanthi, next one is I'm a legal US permanent resident slash green card holder for over 4 years now, and I've never had any issues re entering the US. Recently, I have been hearing horror stories of people being detained at the airports. I had a minor traffic violation last year, turning right on a red light on my record, but that was already been closed. I've paid the fine and attended driving school again as suggested, and it was also removed from my DMV records. I've since re entered the US several times without any issues. I'm traveling to visit family in India for 14 days, but given the current climate, I'm worried if this will get me detained or if I'll be good to go. I have no criminal history or any other issues on my record.
So the question is whether you're turning on a red light, is it just a traffic violation or is it a criminal violation? If you were charged with a misdemeanor because there was some endangerment that took place because you turned, then you might have an issue, because I know you may not have had an issue in the past, but under the present administration, they are looking at misdemeanors as well as a way to stop people from entering into the US. So even though it's been expunged, even though it happened a while ago, I'm not saying that they absolutely will not let you in the country, but they might give you some trouble. But this is only if it's a misdemeanor or a criminal case. But if it was just a traffic violation, pure and simple, and you got a ticket, then that should not affect your travel.
Thank you. We have another question from our stream. Any idea when shutdown ends and DOL opens?
I wish I knew. Even our lawmakers don't know that. The president doesn't know that, so I don't think I would know that either if they don't know. So we don't know when the shutdown will end. I wish I did know, but I don't. And the DOL will open, of course, as soon as the shutdown ends. And this can happen with very little notice, so it can just happen immediately also, right? We know that. So I would say that prepare your application, keep it ready. Soon as the shutdown ends, you should be ready to file it.
Great. That's all the questions we have so far. If anyone has any other questions, feel free to drop in. Here are a few ways. Again, we've gone through this many a times in the past as well. So for those who are joining us for the first time, Prashanthi can help you in many ways. Here are some. With a huge number of clients served over the past 20, 25 plus in the industry, Prashanthi has the experience and expertise to serve you, and the raving testimonials, whether it is on Google or our website, is a testament to the work that Prashanthi does to serve the community. Today, as a token of appreciation for joining the session, everyone is eligible for an early bird complimentary session. In order for you to qualify, all you have to do is just drop in your email either on the chat window or DM us using any of the socials, or you can email us as well. Someone from our team will reach out to you and schedule an early bird complimentary session with Prashanthi. On that note, I will wrap up today's session. Prashanthi, any final thoughts before we part for this one?
I think with reference to the H-1B proclamation, wait and see. I forgot to mention that there is a immigration update today, which came out just today, and I want to make everyone aware of that. This is completely, a hot topic. USCIS has stopped automatic extensions of EADs. As you know, in the past, whether if you are on a H4 or a 485 EAD, you had automatic extensions because the processing time of the EAD was so long that people were had to stop working. The USCIS came up with automatic extensions last year and the year before, and as long as you filed your petition on time, your EAD on time, you were allowed to continue working. Now they have removed that. There is an interim final rule, and it's effective as of October 30th. And there is no publication requirement, no comment period required, because it's done as an interim final rule. So it's effective immediately as of the date of publication, which is October 30th. So for those of you who need their EADs to be extended, please do this in the maximum allowable time, which is 6 months before expiry, so that you do not have to stop working. This is a hot news and an update which came out just today. Not very good news, but I'm hoping that maybe there will be a lawsuit filed, because there is no good cause for doing this as an interim publication and not having to go through the publication and comment period. Usually, if there is a regulation, all regulations have to go through a comment and publication period, and then then they finalize it. They've circumvented that by saying that there is good cause, but I don't really see any good cause for being in such a hurry to propose such a regulation. So I'm sure that there will be some lawsuits filed, and maybe the courts will force them to go through the comment period, and we can delay this, hopefully. But as of now, as of October 30th, no automatic extensions for EADs.
Thank you, Prashanthi, for the update. All right. Once again, thank you everyone for joining today's session. We will be hosting the next webinar sometime next month. If you have any topic recommendation, do let us know. We would be happy to pull in. I would also remind everyone that Prashanthi comes in front of camera way often these days because of your request and your questions. So we are currently running 2 video series. One is the Friday immigration series, and the other one is something that we run on Wednesdays. So if you have any questions related to the topic, it is Ask Prashanthi webinars video series or Immigration Friday series. Do drop in your question using any of the social platforms, or email us, and we would be happy to let Prashanthi know so that Prashanthi can take up those questions during the Ask Prashanthi video series. Thank you once again for your time today, and we look forward to seeing you in the next one. Thank you, Prashanthi.
Thank you. Bye.